Hi, I'm Micah Jachi, and this is Burden of Proof, where we'll be covering high-profile cases taking place all across the nation. We've got a big show for you tonight, starting with the prosecution resting its case in the trial of Duane Keffe D. Davis, the man charged with the murder of rapper Tupac Shakur, and later the latest in the high-profile murder trial of Lindsay Clancy. I'm joined by two illustrious lawyers. To my right, criminal defense attorney Brian Buckmeyer. Brian, how you doing today, man?
I'm feeling good. We got two cases coming to an end soon, but we just can't heat it up here, so it's going to be a good time.
I like to hear that.
Yeah.
And to my left, criminal defense attorney and former prosecutor Bernarda Villalona. Bernarda, how are you? You ready to go today?
I'm ready to go. Things are coming to an end, so finally the people will decide whether the burden of proof has been met.
All right, we will. Now we're going to kick things off with the murder trial of Duane Keffe D. Davis in Las Vegas. Prosecutors resting their case after calling the final witness to the stand. Defense attorneys are expected to call their own witnesses beginning tomorrow, including members of the Las Vegas Police Department. Let's bring in ABC's Alex Stone, who's been tracking this trial for us since the beginning. Alex, what happened today in court?
Yeah, this was really quick. Even the judge saying, wow, we're already done. We're way ahead of schedule. The prosecution resting today after only a week and 2 days. Going into this, the expectation was it was potentially going to be 6 weeks, that it could have been a month-and-a-half long trial. And they said that they were done today. But they've never shown any real concrete proof that Duane Davis was involved in this. It's been a lot of playing of his words. Will the jury believe what he has said for so many years in police interviews, in media interviews, in a documentary, as that being fact of what actually went on? Or are they going to say, hey, show us something that can actually show he was in Vegas that night? Yesterday, a former Compton cop told the jury that they did find Vegas receipts in his home years ago when they raided his home, but couldn't specify what the hotel was, what the dates for the receipts. There were some money demands in there for somebody else that went on in Vegas, but couldn't really say all these years later. It was just listed in an evidence log what they were for and what they said. And the prosecution has not called the author of the co-author of Davis's book because Davis has said, hey, I didn't write that book. Somebody else wrote it for me. I gave him some details and then he embellished it. And defense attorneys are going to say none of that was true when they get up and begin presenting their case tomorrow. But they haven't heard from the author of the book. The author was not called.
Yeah, instead of he said, she said, this trial looks like it's turning into he said, he didn't say. Now, what can we expect tomorrow?
Yeah, you're right. This is going to be all about which version of what he has said is true. Either is it now when he says that this was all about selling books and trying to get a better deal and the proffer agreement, this kind of immunity-like deal where he had to help out police to give them something. So was he just giving them something so that he could get a better deal in a drug case and his involvement? But tomorrow, we understand the defense says they have several police officers who they're going to call. They think it's only going to go several hours. The prosecution says that they've got 3 rebuttal witnesses, and the judge said this could very well be done by tomorrow night. Now, closing arguments likely won't be until next week. They've got some administrative stuff to take care of on Friday to go over what the jury instructions are going to be and other things, but looks like probably Monday closing arguments. Much quicker than what we thought going into this 2 weeks ago.
Yes, a lot quicker. Alex, thank you for that. Let's bring back in Brian and Bernarda. Brian will be giving the perspective of the defense, and Bernarda will handle the prosecution. Okay, Bernarda, I want to go to you. Okay, this feels like it is quick to already have the prosecution resting. What's your take on that?
Well, the prosecution has been efficient. We knew from the very beginning that this case is going to rise and fall on the various statements that Keffe D. Davis made. And today they ended on a strong note. They rested on a strong note, and that being the interview that he gave to Vlad TV, where at one moment doing the interview, Keffe D. Davis literally takes his book and says, look, get the real truth about the whole situation, get my book. And he actually flashes it to the camera. So again, bringing emphasis that the real truth and the truth about what happened that night is based out of the words of Keffe D. Davis. So we'll see ultimately whether the prosecution has proven a case beyond a reasonable doubt. But more importantly, the judge did give Keffe D. Davis today his warnings in terms of whether he desires to testify. So let's see if he wants to keep on talking.
Yeah, so we're essentially seeing right now, yeah, exactly. But we're seeing right now the prosecution hinge everything on Keffe D's words, his books, his interviews, with the FBI and with Vlad TV, so on and so forth. So as the defense, how are you prepping for tomorrow to kind of put a bow on everything that you've been trying to argue this time?
So there are two ways of handling this. And depending on what the defense has and the evidence and their confidence, they'll probably pick one or the other. It's either option A is you simply say the prosecution hasn't proven their case. It's quick and efficient, like Bernard has said. And the reason why it's quick and efficient is because what they sold you at opening statements is what they could not provide to you in this case, and they haven't met their burden of proof. And you just hold on to that burden of proof and just argue they haven't met it, they haven't met it. The other option is a little bit more dangerous, but if you're going to swing for the fences, you take on a case of your own and you try to prove why the prosecution is wrong. You put on witnesses, you put on experts, you put on people that can say what he said was not corroborated in actual reality, and this is why it's false. It's difficult taking on a burden. Some people do, but I think those are the two options here.
So the problem that the defense has is, while they're saying in their opening statement that all those interviews were a lie and it was to make money, you haven't heard that from the witness stand, because the witnesses that the prosecution has called has put in all these statements that Keffe D has made, and none of those statements said, I gave those statements to make money. So you didn't hear that in the proffer audio recording. You didn't hear that in the other audio recording. You didn't hear that in that interview having to deal with Death Row Chronicles. You didn't hear that today in the Vlad TV interview. So if the defense wants to say that it's all a lie, are you only going to say that during closing arguments when there's not one piece of evidence that was presented from the witness stand saying that it's a lie? Or are you going to put Keffe D Davis to get on the stand and say, hey, I did it for the money and what I said was a lie. I fibbed in order for me to get money. But then you're going to have to be able to answer a lot of questions having to deal with the proffer when money wasn't being offered to you. And of course, you're going to have to answer up that you essentially became a cooperator, a rat.
Now, Bernard, there's a lot of things that happened on the witness stand, actually. During yesterday's testimony, witnesses laid out that they saw what they photographed on the night that Tupac was actually murdered. So how important is the history of gang hierarchy and the culture of gangs essentially to this case right now?
It's part of the charge. So it's crucial for the prosecution case because you also have to prove not only that Tupac was killed, but he was killed also in furtherance of criminal gang activity. So that's why the prosecution had to put on these gang experts and people that were in the game back in 1996 to show and to prove and put evidence before this jury that Keffe D Davis, he was a Crip member. Not only that he was a Crip member, but he was high up in that hierarchy, and that he because he was so high in that hierarchy, when that shooting took place inside of that vehicle, that he had to have given the order for Orlando Anderson to have fired before he actually fired.
Right. Now, Brian, the jurors, they heard various recordings of phone calls that Keffe D Davis talked about, where he essentially talked about blood being on his money. So how bad are these calls for the defense right now?
It's bad because it's strong. It's what I would call strong circumstantial evidence, right? You have a situation where he's making that statement after giving an interview, and the strong suggestion is that the blood on the money he's receiving for doing these interviews, for doing these kind of speaking engagements, is the blood of Tupac Shakur, that he's getting paid to talk about a murder that he committed. And that's a very rational explanation, right? But the defense job is to show that circumstantial evidence has gaps in between it, that there's reasonable doubt. One example I give to people is, I wear a wedding band. Could mean that I'm married. It could mean that because when I'm in front of a jury, I believe that people think that married men are more believable, and maybe I'm lying. Who knows? But that's up for them to decide whether it's reasonable doubt or not.
Okay, we're going to have to wait and see. Thank you, Brian and Bernardo. Stick with us. Next up, the Lindsay Clancy murder trial is nearing its end. A judge has sent the jury home ahead of tomorrow's closing arguments. Our powerhouse attorneys walk us through the art of the closing. That's all next. Welcome back to Burden of Proof. We're going to turn now to the murder trial of Lindsay Clancy. Attorneys for both sides will make their closing arguments to the jury tomorrow morning after hearing from a total of 84 witnesses over 21 days of testimony. Clancy's defense attorney, working to poke holes in the prosecution's case, claiming she was suffering from postpartum psychosis, when she killed her 3 children back in 2023. Let's bring in ABC's Rena Roy, live from outside the courthouse in Plymouth, Massachusetts. Rena, the prosecution resting its case today. Give us the details on what exactly happened today in court.
Yeah, well, Ike, I got a chance to go inside the courtroom here behind us as the last witness took the stand. And let me tell you, the courtroom was completely packed start to finish. This was testimony from a senior psychiatrist with the FBI named Gregory Sathoff, who interviewed Lindsay Clancy earlier this year for about 11 hours. Jurors were listening very closely, taking notes, seemed to be extremely focused up until the very end of this trial. Clancy appeared to be very stoic. Sathoff said in his opinion that Clancy should be held criminally responsible. He testified that he believes Clancy carefully planned the killings to avoid witnesses and that she knew what she was doing. But her defense attorney attempted to poke holes in his testimony, trying to prove that Clancy was in the thick of postpartum psychosis and reiterated some of the challenges she faced while trying to get help, Ike.
Now, Rena, what comes next after closing arguments tomorrow?
So we just got word a short time ago from the judge this afternoon that he will allow both sides 1 hour each starting tomorrow morning for closing arguments. Then the jury will be instructed by the judge on how exactly to interpret the law in this case. That, of course, is called the jury charge. It is possible that deliberations begin by noon tomorrow, Ike.
Boy, thank you for the update. So what strategies could both sides use? Let's find out in the segment we call Lawyer Up. Brian and Bernarda are still with me, and Brian will be giving the perspective of the defense, and Bernarda will handle the prosecution. Okay, Bernarda, I'm going to start with you. The testimony from the final witness maintained that Clancy did have the capacity to appreciate right from wrong on the night she killed her children. Now, he specifically pointed out the timing of the murders, the fact that she was home alone after sending her husband on an errand. So, did he do a good job of poking holes in Clancy's defense?
I think he set the stage, just like the other 2 rebuttal experts have done. While they all 3 have different conflicting testimony in terms of what Lindsay Clancy was actually suffering, all 3 were clear that she was not suffering under postpartum psychosis at the moment as she killed her 3 kids, mainly because of the length of time it took to kill the 3 kids. So I think they narrowed it down that the husband, Patrick, was out of the house for about 54 minutes, less than an hour. But they believe that the killing of the 3 kids took about 18 minutes. So if I were the prosecutor in this case, knowing that timing is my strongest piece of evidence in disproving that she was under a postpartum psychosis, those 18 minutes, we're about to sit in silence for 18 minutes because I want the jury to feel how long it is for 18 minutes to pass, because they will have to think that this command that she was getting was consistent for 18 minutes. And I think it was very strong evidence by the 3 experts that it's highly unlikely that a psychosis will last that long.
Now, Brian, you heard the prosecution right there. But the defense's strategy is centered on creating reasonable doubt and presenting evidence that Clancy was experiencing that mental health crisis. Now, you heard the prosecution saying 18 minutes. That's long for a crisis. What are you going to say when the defense is done with that cross-examination?
So I'm going to do this a little differently, right? I know that you're a new father as well. 18 minutes when you got a child can feel like a lifetime.
Yeah,
and it's different when you're in the throngs of postpartum psychosis, when you have a child and when you don't. So yes, do what the prosecution is doing. Wait 18 minutes. Then I would tell all the parents, what does 18 minutes feel like when you're with your kid? Very different. It's one thing to be Monday morning quarterbacking about what happens in someone's mind. It's a different thing to actually live and experience it. And I would draw that parallel between being a parent in the middle of it and being able to sit in the jury and just talk about it. So I would start there. In terms of the actual argument that we're making here, I think it's 2-part. One, I'm attacking the prosecution that they didn't prove their case. Where is the intent? You're simply saying that because she told her husband to go off and go on an errand and had to show how long it would take. There are husbands out here who go to do errands for their family and are asking, which diapers should I bring back? What should I get? She's helping a person to do the job because she has been doing it for so long with these 3 kids. I'm making those arguments. And then I'm following up with the fact that this was a battle of experts and I won. she was suffering from postpartum psychosis, and we go from there. But I think there's a little thing inside there as well. They asked for a lesser included, involuntary manslaughter or manslaughter. That's up to 20 years in prison. I'm talking to my client. I'm saying, hey, I might argue this because if they are so strung up on these two charges, maybe we get manslaughter. Maybe you get 5 years. You've already been for 3 years. Maybe you get out in 2 years, and you're not waiting for a mental health check to get out of a mental health facility.
Okay. So
I have to say, as the prosecutor, looking at these charges and looking at this postpartum psychosis, I would take a win as the jury coming back with involuntary manslaughter.
why is that?
Because let's be clear, if they find her not guilty because she lacked criminal responsibility, then she gets confined to an undetermined amount to a hospital, right?
Right.
But she's only in a hospital until it's deemed that she is safe to herself and to others. The woman is paralyzed. So because she is paralyzed, she's already been under medication, so she has the mental health under control. What threat will she be to others? So technically, we're talking about Lindsay Clancy, if they find her not guilty because she lacked criminal responsibility, that she can be out in the streets in a year.
That's a good point. All right. So closing arguments are coming. What do we expect?
Closing arguments, the same thing as I stated before. This is your last chance to speak to that jury.
Right.
And you're going to have to come out, blow it with blows from the very beginning to the end. And also, you're going to have to concede some points if you want credibility with this jury, because I think the prosecution lost credibility with their opening statements when they tried to minimize that suicide, that maybe she faked the suicide, and even her own experts say there was no faking of the suicide. This is clear what she tried to do. So breaking down the timing, focusing on the expert testimony, focusing that her own doctors that observed her and met with her, at no point did they note any suicidal ideations or any plans to hurt herself or her children. And we're talking about just the day before she actually sought medical treatment. And also, I want to focus on the testimony from Patrick Clancy, because he called her shortly after she killed her 3 kids, and there was no sign that someone was talking to her, or she was saying that I just killed the kids, or someone's telling me to do something, or I'm about to kill myself. Because it's clear, by the time that she spoke to her husband, Patrick, she had not jumped out of that bedroom window. So that means that at that point, she wasn't under psychosis.
Okay. Coming up, convicted killer Brian Kohnberger trying to take back his guilty plea. Why a judge is willing to hear him out right after this. Now to On the Docket, where we take a look at other high-profile cases. First up, Meta reaching a landmark settlement in its social media trial. The agreement will require the tech giant to pay up to $18 billion over the next 10 years and forces Meta to make major changes to Facebook and Instagram. Users under 18 will be subject to a daily time limit of 2 hours, and Meta will also stop showing numbers of likes or reactions, and those young users will have access to a non-personalized feed, which doesn't use an algorithm to target them. Meta did not admit wrongdoing in the agreement to the settlement, and a federal judge has lifted all legal obstacles preventing President Trump's executive order aimed at restricting mail-in voting ahead of the midterms. The order clearing the way for new USPS requirements for absentee ballots and the creation of a list of eligible voters in each state. The first wave of mail-in ballots are expected to go out next week. And convicted murderer Brian Kohnberger has been granted a hearing as he looks to withdraw his guilty plea. Kohnberger had admitted to the Idaho college killings, pleading guilty in July of last year, and he was sentenced to serve 4 consecutive life sentences. Now, Kohnberger says he was pressured to make a false confession. And Kohnberger's former attorney declined a request for comment, and his new evidentiary hearing has been set for June 2027. For more on bringing back Brian and Bernarda, what can we expect to come out of Kohnberger's evidentiary hearing here?
Well, the evidentiary hearing, the one thing you are going to see is that colloquy that the judge had with Brian Kohnberger, where the judge asked him whether he's pleading guilty because he is in fact guilty, and also the questions that he asked, whether this plea is knowingly being made, is it voluntarily being made, where you promised anything in order to enter into this plea. So in a case like this, the prosecution is going to be using his own words against him to show that this plea is now at this point is buyer's remorse when it comes to Bryan Kohberger trying to withdraw his plea. I will say this, in the unlikely chance that he gets his plea back, the government can still go forward with seeking the death penalty in this case.
Okay. Now, Brian, what does Kohberger have to show the court in order to be granted a new trial? What does he have to do here?
So he's got two major arguments here. One, he's arguing ineffective assistance of counsel. That's going to be difficult because you can't just show that a defense attorney was incompetent. You have to show that their incompetency actually impacted the way this case was resolved. I don't know why they do this in law school, but the example they always give is like if the defense attorney is even drunk, if this person still ends up convicted because all the evidence was there, that attorney is not ineffective. Maybe it's a kind of a joke on our profession, but that's how the examples usually given. The other one was what Bernardo was talking about, is that he has to show that his plea was not knowing, voluntary, or intelligent. And the way it works in courts is the chief judge or the highest judge has a whole booklet of how you do pleas, and the language is very blow by blow, supported by state law as to how you lock in a plea. There's a reason why these colloquies are so formulaic, because they do it so they can lock you in. So you can't say, well, someone else promised me something. No, I asked you that question. Well, I didn't know what I was pleading guilty. No, I asked you that question. Well, I was high as Georgia Pine at the time. Well, no, I asked you that question. And so all of those things are very difficult because the courts make it difficult for you to take back your plea in this exact situation.
Is this common, Bernardo, to see someone go through this process?
Oh, yes. It actually is common. It is common. It is common. I call it buyer's remorse, is that especially when you have a defendant that has never served time before. And Bryan Kohberger, after he was sentenced, he went to real jail, right? He went to prison. So remember that earlier on when he first got to the prison where he's at right now, he made some complaints of how he was being treated. So I think this is his way out to be like, wait. I don't know what I was getting myself into. I need to try to get my plea back and change what happened.
Being a criminology student doesn't prepare you for real life in the criminal justice system, unfortunately.
Appears not.
No.
All right, Brian Buckmeyer. Bernardo Villalona, appreciate you. Thank you for joining us. I'm Mike Ajachi. We'll be live weekdays with new episodes right here on ABC News Live at 5:30 p.m. and 8:30 p.m. Eastern. And if you missed any part of today's episode, you can check it out on demand on Disney Plus, Hulu, or wherever you listen to podcasts by searching Burden of Proof.